Welcome to Dorsey and Whitney's webinar on running the long emergency, sources and limits of executive power over Minnesota business in the time of COVID-19. I'd like to introduce Steve Wells, a partner in Dorsey's trial group. Steve?
Thank you and welcome everyone to our webinar on running the long emergency. Probably should be running the very long emergency based on a lot of recent news. Let me do a little housekeeping before we get started. Our program today is going to be 60 minutes long. The materials and attendance form can be downloaded from Dorsey, and we're going to send you a reminder email with those forms, and you need to return it completed to attendance@dorsey.com, and that'll be on the email. If you have questions, I think we're likely to take up the entire 60 minutes here because we're going to be going into some depth in a lot of different topics. But if you have questions, you're welcome to contact any of us, any of the presenters, or call any other trusted Dorsey lawyer that you regularly deal with. But please feel free to send us emails if you have any follow-up questions. Next slide, please. So our speakers today, I will be leading off, and just so you know, I'm located in Dorsey's deluxe broadcasting studio, also known as my dining room table. We're all the speakers here are broadcasting remotely. I'm the co-head of the appellate group and have been a partner at Dorsey for about 35 years. Also, next will be Tim Droske. Tim is of Counsel at Dorsey and is the other co-head of our appellate group. Anna Finstrom is an associate in the trial group and our commercial litigation group. And Ian Blodger is an associate at Dorsey in our securities litigation group. And we're all very interested in executive power and how it gets used. Next slide, please. I'm going to start with the federal sources of executive power. And we'll spend some time on this and then some on the state component of executive power and the sources for Governor Walz's proclamations. But the starting point really for the exercise of federal presidential power is both the United States Constitution and then more importantly in this area, federal statutes, authorizations that come through federal statutes. Next slide, please. Generally, as a source of executive power, should probably know, Article 2 of the Constitution establishes the very general powers of the executive and the president. But unlike the legislative powers, which are very specifically enumerated, there's very little specificity in the federal Constitution about exactly what powers the president has, and particularly as it relates to emergencies. And of course, presidents have been allowed to fill in the gaps. But in the emergency area, really the executive's use of the power of the Constitution, kind of a notion that there's an inherent power to issue emergencies and to deal with emergencies, has really taken a backseat to legislative authorizations. Next slide, please. And why don't we skip this slide and go one more slide, please. The president is authorized to act in times of emergency by a variety of different legislative authorizations. The Defense Production Act, the National Emergencies Act, the Public Health Service Act, the Stafford Act, and the Immigration and Nationality Act all provide different sources for the president to act in times of national emergencies generally, and specifically in connection with health emergencies. And as the previous slide just indicated, those powers have been upheld time and again by the courts. And in fact, they're very seldom limited when they're exercised. It's really only when a president has tried to basically sort of nationalize a business, such as the Youngstown Steel case in 1952 in connection with the Civil War, where the courts have really pushed back. Next slide, please. The first act I wanted to talk about here is the National Emergencies Act. This is 50 U.S.C. 1621 at SEEK. And this allows a president to declare national emergencies by proclamation, essentially. And it gives very, very broad powers to the president in a variety of different contexts. There are currently 30 active national emergencies that were declared, some as much as 30 or 40 years ago, that are still in effect. And in fact, the average national emergency lasts for 10 years until it's terminated. We've listed a couple of here, ones that you were probably familiar with, the September 11 attack, obviously. You may have forgotten that the H1N1 pandemic was declared to be an emergency under the National Emergencies Act by Barack Obama. There have been two national emergencies declared by President Trump. One has to do with the wall, the border wall, and then the other one was with COVID. Next slide, please. The reason why we're going to talk about the Defense Production Act here is because the National Emergencies Act, although an emergency was declared, has been used very sparingly by President Trump. He declared the national emergency under the Health Emergencies Act on March 13, 2020. It's almost quaint to read the proclamation that declared this then. At the time, 1,645 people in 47 states had contracted COVID. And the use of the executive power here was very limited. The president declared that basically they empowered Health and Human Services to waive certain requirements of Medicare, Medicaid, HIPAA, and other health statutes. And that was it. There really wasn't a very in-depth invocation of those powers, and they were used very sparingly under that act. The next act that gives presidents the power to impose control over businesses in times of emergency is the Defense Production Act. And this is a more limited act that authorizes the president to control aspects of the domestic economy, usually involving industrial production. It's usually used to promote national defense during times of emergency. The next slide, please. This was passed in connection with the Korean War, and as I said, it's usually used to regulate private industry to facilitate national defense. And in fact, this president and many presidents before him have used the DPA literally thousands of times to make sure, for example, that critical components of military equipment or military ordnance are available to the military. It doesn't enable Congress to take over a business, or the president rather, to take over a business, but it does allow the president to take action to ensure that there's an adequate supply of critical items for public use going forward, and to guarantee public access to goods. Now, President Trump, in connection with the COVID pandemic, has used the Defense Production Act essentially 3 times, and 2 of them have to do with Minnesota businesses. One of them specific to Minnesota business. As you probably recall, the president invoked this act to ensure that 3M essentially both produced sufficient N95 masks and had them available to the federal government for their use. There was also a invocation of the DPA to keep meat packers running, including meat packers in Minnesota. Not limited to Minnesota, but it affected a number of meat packers here. And then the president has invoked the DPA to ensure a supply of ventilators from General Motors. But again, a fairly sparing use of the Defense Production Act as it applies to COVID, particularly in contrast to the extensive use by President Trump and many other presidents in using the DPA to ensure an adequate supply of military goods and components for military equipment. It is generally thought that the DPA is used in connection with national defense, and that is probably how it's most often used. But the DPA also includes by tying into the Stafford Act, which we're going to talk about in just a minute, the ability for the president to use the DPA in connection with health emergencies. Next slide, please. So the Public Health Service Act is an act that allows, 42 USC Chapter 361, allows the Health and Human Services Secretary to take certain actions such as quarantining, such as expanding availability of healthcare and dealing with the availability of protective equipment, for example. It has less to do with control and more to do with availability of equipment and related items to ensure the public health. But it can be used, I guess its most prominent use in connection with businesses anyway, is to impose quarantines at times. Next slide, please. And that brings us to the Stafford Act, which is the act that was passed in the 80s that really created FEMA. And this allows a president to declare an emergency in connection with a natural disaster or even a health disaster, allows FEMA to respond, and taps essentially disaster relief funds for direct aids to the states. So this one, it has less, also has less about it that relates to control of businesses and is designed generally to provide assistance to businesses. Next slide, please. Just touch briefly on the Immigration and Nationality Act, which gives broad powers to the president and executive agencies with regard to immigration enforcement, and allows the president to restrict immigration and travel into the U.S. in a variety of different contexts, including a health emergency. Next slide, please. So now let's turn to the state, the powers of the state executive and where those come from. We start with, of course, the 10th Amendment, which reserves to the states all of the powers that are not delegated to the United States by the Constitution. There's also something called the anti-commandeering doctrine, which holds that Congress may not commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program. And each state's constitution and statutes establish the balance of power between its own branches of its government and how it can be used, how the executive power is used in an emergency situation. Next slide, please. Article 5 of the Minnesota Constitution establishes the office of the governor and enumerates certain powers and duties, but is relatively, it's much more specific than Article 2 of the United States Constitution, but doesn't say much, frankly, about the governor's powers in the face of an emergency. Those powers are really found, next slide, please, in Chapter 12 of the Minnesota Statutes, which allows the governor specifically to exercise emergency powers. And Section 12.31 of our Minnesota statutes is devoted entirely to peacetime emergencies and describes the powers that the governor has to declare a peacetime emergency and also set the parameters for it. And the balance that the legislature took in setting up the governor's emergency powers and kind of delegating to the governor the power to deal with peacetime emergencies, including health emergencies, was this. The governor has sweeping powers, very, very broad powers under this statute, but they only last for 5 days unless something happens. And a peacetime emergency lasts by governorial proclamation for only 5 days, and then that can be extended by resolution of the Executive Council for up to 30 days. The executive council is the governor, the lieutenant governor, the secretary of state, the auditor, and the attorney general. That's how it's been extended here. And the legislature has termination rights, but the legislature doesn't have to reauthorize, as long as the executive council in Minnesota continues the peacetime emergency. The legislature has really only termination rights. And there is this interesting provision which we're seeing play out right now in Minnesota, which is that if there is a peacetime emergency in place, the legislature has to be in session at some time during that 30-day period so that they can vote yes or no to terminate the peacetime emergency. There are also some provisions in Chapter 9 of the Minnesota statutes which relate to the executive council specific rights to take action with respect to peacetime emergencies, including disease. But in practice, this becomes really the governor and the governor's administration that controls the issue. So now I'm going to turn it over to Tim Droske to talk about some constraints on executive power.
Thanks, Steve. Tim Droske here. And, Steve has just kind of set out the sources of executive power, both at the federal level for the president and the state level for Governor Walz. And we are a government that has a system of checks and balances. And so embedded within the US Constitution are certain structural restraints, both in terms of the interplay between state government and federal government, the different branches of government. And then through the Bill of Rights, there are also certain, individual liberties and rights that are given to the people. First to the federal government in the Bill of Rights, and then through the incorporation doctrine through the 14th Amendment. Those are all also applicable with respect to state laws. And so what we're going to do now for the next chunk of time is walk through some of these different constraints and limitations. I'll give the caveat that there's a lot to cover here. There are a number of different arguments that could be raised. And so as a result, I'm not going to be strictly wedded to the slides. So you have those as a resource, but I'll be talking a little bit more freely. I'll also kind of say that as a general matter, especially for the business community, there are a number of different constitutional arguments that can be thought of, that you could potentially raise to challenge or push back on some of the restrictions and regulations that have been imposed, at a state level in particular here in Minnesota. But the ability for those kind of arguments to gain traction and win is going to be much more difficult. And I'll talk about that a little bit, and then Anna and Ian will discuss that even more on the back end when discussing some specific cases. So next slide. So first, at an overarching level, you have certain constraints on executive power, and some of those just come from the people, right? We're going to have a presidential election in November, and so elections are a form of political accountability. And so we'll have that at the federal level coming up here in the fall. There are also legislative checks, like Steve just described in Chapter 12 of the Minnesota Statutes, allowing the different branches of government to provide a check and balance on the broad scope of executive power that's generally allowed in kind of these peacetime emergency situations. Impeachment is another way of checking executive power. President Trump has been impeached already once during the course of his presidency, and that is an available means of constraining executive power. Similarly, at the state level, different states have recall procedures. I think the most famous example is a number of years ago in California when Governor Davis was recalled and Arnold Schwarzenegger then became the governor of the state of California. Minnesota also has a recall procedure, and here there was actually a recall petition to recall Governor Walz, claiming that his actions exceeded the authority that he's given under Chapter 12. The process is the recall petition ultimately went to the desk of the Minnesota Supreme Court Justice, Chief Justice Gilday, and she found that, and she dismissed the recall petition. She said essentially, even if all the allegations in the recall petition were accepted, there's a higher standard where it's not just whether the governor acted lawfully or unlawfully, but he needs to have acted with malfeasance. And she said that standard couldn't be met here. And so there was a recall petition, but it was dismissed. But it is, again, a check and a constraint on the scope of the executive. Next slide. So now we'll start walking through some of the other, constraints embodied in the Bill of Rights, as well as kind of within the structure of the Constitution. And it makes sense, I guess, to start with the First Amendment, which does have protections for, freedom of religion, freedom of speech, the right of people to peaceably assemble, and you see the text of the First Amendment there. Next slide. Yeah, and the First Amendment actually has been invoked a lot in different challenges to different orders from different governors. And again, Anna and Ian will talk about that a little bit. I'm not going to focus on that too much, though, because the bulk of those challenges have been focused on the freedom of religion provision. Governors' orders have often restricted places of worship, gathering for Sunday service or Sunday Mass. And there have been challenges that have been brought to that. I think the main takeaway is that so long as the governor is not actively trying to discriminate against places of worship, that there's then kind of a standard of scrutiny and balancing that's applied by the courts. And sometimes, but not always, it's been found that the governor has been acting lawfully, especially if you can identify that the governor is treating places of worship similarly to other, whether it's, theaters or schools or other places that have similarly been affected and restricted due to COVID-19. But the challenges have certainly been raised. Next slide. The First Amendment also includes within it a right to assemble. There's this very idea of a government that implies a right on the part of its citizens to meet peaceably for consultation, especially in respect to public affairs, and to petition for redress of grievances. So people are allowed to assemble, and certainly there are restrictions on people gathering and assembling. The principle, that the Supreme Court has articulated, that you see in the next bullet, is that so long as a state is issuing general and non-discriminatory law that's regulating things like the times, the places, the manner of soliciting upon its streets, and holding meetings, it can do that. Again, if it's general and non-discriminatory in nature, it can impose limitations that are designed to safeguard the peace, good order, and comfort of the community without unconstitutionally invading the liberties protected by the 14th Amendment. And so those guidelines give states and the federal government, but they haven't been exercising it as much, a lot of leeway in terms of the kind of regulations that they can impose. Next slide. So a big bucket that a lot of constitutional challenges are made under is the Due Process Clause. And so the Fifth Amendment of the Constitution prohibits the federal government from depriving any person of life, liberty, or property without due process of law. And the 14th Amendment imposes the same prohibition and incorporates that to state governments. Now, the Due Process Clause has two components to it. It has a procedural component and a substantive component. The procedural component is that the government can deprive a person of life, liberty, or property so long as they've given due process of law. Are there certain procedures in place? And kind of the touchstone case for that is Matthews v. Eldridge, which from the U.S. Supreme Court, which set out kind of the requirements for procedural due process. So here you could have challenges, as different stay-at-home orders are issued or restrictions on businesses are put in place. There could be arguments in terms of the procedure that happened there. But if the governor's office, for example, were to allow there to be some sort of petition process where a business that was deemed non-essential could petition to be essential, courts could then look at that and try to determine whether or not adequate process exists here. And certainly the fluidity and need to act quickly in response to an evolving COVID-19 pandemic probably means that less procedures are going to be needed than otherwise might if there wasn't the need to move in such exigent circumstances. The other component of the Due Process Clause is substantive due process. And if you go to the next slide, the substantive due process means that there are certain, just categories or areas or fundamental rights that are protected by the Constitution. Now, if we lived over a century ago and this pandemic had happened, we would have been in the middle of the Lochner era of the Supreme Court, which, you know, maybe you remember from law school and constitutional law, hearing about that. But there was a period of time from like the 1870s to through the 1930s when the Supreme Court found that there was this substantive due process right to liberty to contract. And as a result, a lot of state regulations aimed at regulating the economy were struck down on that principle. During the New Deal era, the court turned away from that Lochner era and that notion of substantive due process for economic rights. And so there's still a modest constraint on the government's authority to regulate business, but it's much more restrained than it was previously. And the Williamson case kind of illustrates that. The day is gone when this court used the due process clause of the 14th Amendment to strike down state laws, regulatory of business and industrial conditions, because they may be unwise, improvident, or out of harmony with a particular school of thought. Next slide. So we'll talk about it a little bit later on. I mean, there are still some pockets and areas where the state can be found to go too far. So for example, if the state is regulating intrastate activity and only allowing a certain class of people to engage in some conduct, you know, so there was a case, for example, where you had a state law that only allowed licensed funeral homes to sell caskets to the public. And you had complaints saying, hey, we should be able to sell these too. Even under a kind of a low level of scrutiny, the court was said, that's not a valid kind of economic regulation. And so there might be some challenges that could get some traction in some courts, and it varies from jurisdiction to jurisdiction. But again, it's going to be difficult. Next slide. The other kind of big constitutional bucket that a lot of arguments are raised under is the Equal Protection Clause. Principle here is that the government shall not deny to any person within its jurisdiction the equal protection of the laws. So again, all people should be treated equally. Next slide. Both the Due Process Clause and the Equal Protection Clause have with them these kind of different standards of scrutiny that are applied. There was this Caroline Products case that the Supreme Court issued almost a century ago that had this small footnote 4 that kind of talked about how there should be different levels of judicial scrutiny. And that has exploded into kind of constitutional jurisprudence as we continue to know it today. If you are able to raise a due process clause claim involving a fundamental right, so First Amendment rights, voting, interstate travel, privacy, those are going to be subject to heightened scrutiny, strict scrutiny. And what that means is the state must demonstrate that its classification has been precisely or narrowly tailored to serve a compelling governmental interest. Now, in many cases, that applying that strict scrutiny standard is viewed as being almost outcome determinative, that is an almost impossible bar and hurdle for any legislation or law to clear. You know, I think what remains a more open question is, can COVID-19 related regulations and laws clear that hurdle? I think courts would generally find that you do have that compelling governmental interest, given that we're in the midst of this unprecedented pandemic. The question would really be in terms of how narrowly tailored the law is. And you can see courts having differing views on that. And it could be difficult with everything kind of being a moving target as we learn more about the virus and as the rules and regulations are kind of continuing to change. On the equal protection front, heightened scrutiny is applied to certain suspect classifications. So any sort of law that treats people of different races differently, or alienage, national origin, sexual orientation, those are going to be subject to heightened scrutiny. If you go to the next slide, everything else is subject to rational basis review. And here, it's a pretty low bar for the law to be upheld. It'll be upheld so long as it bears a rational relationship to some legitimate end. So, you know, responding to COVID-19 is certainly going to be deemed as a legitimate end. And so long as you can come up with some sort of nexus between the, you know, requirement that's being challenged and COVID-19, it'll be upheld. The problem for the business community is it can be difficult to fall in those fundamental rights or suspect classification boxes that would subject you to heightened scrutiny. So a lot of economic regulation is going to be subject to rational basis review and going to be difficult to succeed on. Next slide. So the takings clause is a more specific constitutional challenge that can be brought. It's in the Fifth Amendment of the Constitution and provides that private property shall not be taken for public use without just compensation. Next slide. And so on the one hand, it seems like that could fit here, right? I mean, businesses have been forced to essentially shutter in many circumstances due to the COVID-19 pandemic and due to, government imposed rules and regulations. It doesn't fall within the classic case of a takings claim, though. That's when, the state's looking to widen the highway and needs to bulldoze a home or a property in order to widen the road. We don't have that kind of physical taking. Now, there is a line of precedent permitting takings claims to be brought with respect to regulatory takings, where the restrictions or regulations on the use of the property are so severe as to require compensation. Next slide. That's going to be difficult to win on here, though, for two reasons. First, it generally needs to deprive the owner of all economically productive or beneficial use of the property. And so here, simply severely restricting how business is done probably doesn't deprive the property of all economically productive or beneficial uses. The other problem in terms of making a takings clause claim is that it's really been applied when there is some sort of permanent taking. And so here, where most of these COVID-19 regulations are recognized to be temporary in nature, even though how temporary and how long it's going to go on is open-ended, and we're still certainly in the midst of it, because they're generally viewed as temporary in nature, it's going to be difficult to prevail on a takings claim. Next slide. So we already talked about economic activity. There is the Commerce Clause. And so the federal government has the ability to regulate interstate commerce. And that also in turn puts a constraint on states known as the Dormant Commerce Clause. Dormant Commerce Clause, it's implied but not expressly in the Constitution, but effectively states can't box out out-of-state companies from conducting business in-state if it's done with a discriminatory purpose of favoring in-state activities. And, again, there'd be kind of the standard of scrutiny applied to the state law. You could see where some of these kind of challenges could be brought here, where, again, I mean, businesses have been, again, shut down and shuttered as a result of the COVID-19 pandemic. But these kind of challenges are unlikely to prevail. If you look at the slide up on your screen, the Supreme Court a century ago, in this case, kind of directly addressed the interplay between the Commerce Clause and quarantine laws and said, the power of the states to enact and enforce quarantine laws for the safety and the protection of the health of their inhabitants has been recognized by Congress and is beyond question. Unless or until state laws are superseded by federal legislation on the same subject, state laws for the purpose of preventing, eradicating, or controlling the spread of contagious or infectious diseases will be sustained, even if their operation affects interstate or foreign commerce. So again, there's kind of this presumption of validity with quarantine laws, which is consistent with states' historic police powers. If you go to the next slide. What the quote we just read did imply, though, that if the federal government gets involved, that would supersede what states do. And that's the Supremacy Clause in a nutshell. The Constitution provides that federal law shall be the supreme law of the land. And this plays itself out with respect to the Intergovernmental Immunities doctrine as well as preemption. And I'll briefly talk on both here. What the Intergovernmental Immunities Clause and doctrine provides is that states can't regulate what the federal government is doing. So ways that this could play out here is if you had federal agents in the state, federal military base, anything like that, and the state, has COVID-19 related orders and directives and was trying to apply those to the federal government that is present here in the state, that would be subject to the Intergovernmental Immunities doctrine. What's significant to know for businesses is that there are cases establishing that federal contractors can also be protected by the Intergovernmental Immunities doctrine. So if a state regulation is impeding your ability to do the work you contracted with the federal government for, that may be a basis for raising an intergovernmental immunities challenge. Next slide. The other interaction between federal law and state law is preemption. Again, this is also premised on the Supremacy Clause, and it has, and preemption can take on a few different forms. Essentially, if Congress or the executive were to expressly say, federal law exclusively controls here, states can't operate, as a general matter, it can do that. Where it becomes more difficult is where Congress hasn't gone that far, and instead you're dealing with implied preemption. Now that can take on the form of where Congress has exclusively regulated an area that the field is just deemed to be preempted. There's no room for states to operate. The other way that this can come into play is conflict preemption. If federal law says you need to do X, and then a state law says you can't do X, even if as a general matter, both federal and state can regulate, if there's a direct conflict, federal law has to prevail. Now, preemption is an issue that could have arisen, but hasn't as much here, largely because the federal government hasn't exercised the full scope of its COVID-19 related authority to the extent it could have. But these issues can also come up at a state level when you have municipalities or counties enacting regulations that may be different than what the state of Minnesota has done at a statewide level. So you could envision, let's say, a county or a city that's been severely economically distressed saying, we're going to loosen some COVID-19 regulations compared to what the state is ordering. Well, that would be subject to a preemption challenge as well. The last one I'm going to talk about, next slide, is the contracts clause. So the Constitution does say that no state shall pass any law impairing the obligation of contracts. The language of that is pretty robust, but its enforcement has been much more restrained. Next slide. The Supreme Court has required that the contracts clause only comes into play when there's been a substantial impairment of a contractual relationship. So has a contractual relationship been substantially impaired? And even then, if it has, there's still kind of this standard of scrutiny that's applied. You know, was the state law enacted for a significant and legitimate public purpose? Is the law, appropriate and a reasonable way to advance that interest? If so, even if the contractual relationship is substantially impaired, the law will still be applied. A few interesting things about the contracts clause. One is it can be applied in litigation between two private parties. So the most recent Supreme Court case, Steen v. Mellon, was a dispute over life insurance proceeds. And one of the parties was the ex-spouse of the person who died, and the other parties on the other side were the children. And they were disputing who gets the proceeds. And Minnesota was the state at issue and had changed its laws for who is kind of the default beneficiary after the life insurance policy had been entered. Supreme Court said contract clause not implicated by that change. The change in the law can still apply. The other interesting thing is there's another Minnesota case. Not only was Minnesota the most recent, not only was Minnesota the subject of the most recent dispute, but also the one that's probably most on point. There was a case, it's not on the slide here, but it's a case, Building and Loan Association v. Blaisdell from 1934. And there the Supreme Court approved a Minnesota mortgage moratorium statute, even though the statute retroactively impaired contract rights. You could see where, we're certainly seeing where mortgage remedies are being impacted by state laws and trying to put moratoriums on things like that. What the Supreme Court said there is, if there's a response to some sort of public emergency, there it was the Great Depression, now it's COVID-19, and the state impairment is really aimed primarily at the remedies as opposed to the underlying contractual obligations, and especially if they're temporary in nature, is generally going to withstand challenge. So contracts clause remains an argument that can be raised, and again, is unique in that it could come up in litigation between two private parties, as opposed to a lawsuit against the state or against the federal government. But history's shown it's probably unlikely to prevail in these circumstances. And with that, I'll turn it over to Ian and Anna for a discussion of some of the cases.
Thanks, Tim. So we have seen these concepts playing out in cases over the last few months all over the country in state and federal courts. I'm going to walk through a few Minnesota cases, and then Ian is going to talk about a few cases from other jurisdictions. The first case I'm going to talk about is the Northland Baptist Church of St. Paul case. And again, I just want to reiterate that we're not digging into the First Amendment claims directly here, but you'll see that the First Amendment claims and the business impact claims are really overlapping, and often we're seeing groups of plaintiffs, who include both churches and businesses, as well as individual people, that help to illustrate how those concepts are often hand in hand under these circumstances. So the Northland Baptist Church group of plaintiffs did include churches as well as businesses and individuals, and they served their lawsuit on Governor Walz and some other state officials in federal court in the District of Minnesota, and they included quite a few counts in that complaint, including free exercise of religion and free speech and assembly, as well as equal protection, substantive due process, a takings clause claim, and then also a claim for issuance of a writ of quo warranto, which would restrain an ongoing exercise of unauthorized governmental power, according to Minnesota statutes. The theme of this complaint, which you'll see, is in contrast to some of the other complaints, and specifically the next case. In the Northland Baptist Church case, the strategy was really to undermine completely the governor's declaration of a peacetime emergency. They argued that the emergency declaration itself was unlawful and unjustified, and then their other arguments followed. We have not seen any substantive decisions on this case, but it is still active. When Governor Walz authorized church services at reduced capacity, in-person church services at reduced capacity, the plaintiffs amended their complaint and withdrew their initial request for a temporary restraining order. And then just yesterday, they actually filed a second amended complaint. So we should expect to see some activity on this case going forward. The next one I'm going to talk about is the Alpha Family Clinic versus Walz case. Again, this is in federal court in the District of Minnesota. And again, the plaintiffs included, the named plaintiff here is a family clinic practicing family medicine, as well as individual healthcare providers in a variety of areas who were not allowed to practice because of the restriction on elective procedures, and then also other individuals who would like to have liked to attend church services but weren't allowed to, as well as several pro-life organizations. So we saw this kind of conglomeration of rights and claims in the group of plaintiffs. The strategy that was really different in this case compared to the previous one is that plaintiffs did not challenge the fundamental basis for Governor Walz's declaration, and fundamentally didn't assert that there was anything wrong with the concept of restricting business and other conduct in order to reduce the spread of COVID-19. But this complaint asserts that the continued availability of surgical abortions was out of sync with the other restrictions. And their arguments were that the general prohibition on elective medical procedures and other efforts to conserve PPE for medical workers, personal protective equipment, and those efforts to enforce social distancing in healthcare settings were basically out of sync. And then additionally, they took this angle that people's fundamental rights to exercise of religion were being restricted, while the right to a surgical abortion, which these plaintiffs assert does not have a basis in the Constitution, that was basically incongruent. So that's kind of the framework for this complaint. The first count was an equal protection claim, and the second count was for a declaratory judgment on the question of whether a surgical abortion is a constitutional right. And they concede in the complaint that position and their request for a declaratory judgment on that issue is contrary to current Supreme Court precedent, but they disclose directly in their complaint that they wanted to preserve that issue for an appeal and eventually a certiorari petition. No decisions were rendered on the merits in that case, and plaintiffs have actually voluntarily dismissed, and that just happened, so it's not reflected on your slide, but so we won't see any further activity on that case. But I will note there were many pro hoc vice admissions of attorneys from out of state on both sides, and so clearly this case reflects some issues and some litigation strategies that we have seen and we could expect to see around the country on these issues. The last case in Minnesota that I'm going to talk about really briefly is a Minnesota state court case. The plaintiffs here were a group of restaurants and bars in Stearns County and the owner and operator of those establishments. he publicly announced that he intended to reopen his businesses, even while executive orders prohibited on-site consumption of food and liquor. And actually, there were some pre-litigation negotiations, both with local law enforcement and with the state attorney general, but they didn't have an agreement, and the business owner in this case again announced that he intended to open contrary to those executive orders. And the way this played out is business owner made his final announcement on May 18th. The state attorney general filed a lawsuit and got a TRO on this the same day, the very day that he would have opened. The parties had a hearing scheduled for May 22nd. In the meantime, Governor Walz came out with his plan for reopening restaurants, which included provisions for patio service, and now, as we've seen, reduced capacity indoor service as well. So some of these issues seem to maybe be becoming moot on some level, although this case is still active. There was a hearing on the state's motion for a temporary injunction on May 22nd, and then on June 2nd, which happened to be the second day that patio service was allowed, the court issued a decision granting the state's motion for a temporary injunction. And I'm just going to read these couple of sentences because I think they really kind of capture the moment. This is Judge Sean Wong in St. Cloud at the St. Cloud Courthouse for Stearns County in the 7th Judicial District. He says, "The court understands and appreciates the economic hardships suffered by the defendants and the people of Minnesota due to the pandemic. While reasonable minds can agree or disagree with the governor's decision regarding the scope of his executive orders, it is clear that the governor has the statutory authority to issue the executive order at issue in this case." And that case, for now, is still active, and so maybe one to watch. I'm going to hand it over to Ian.
So those are some cases that we found from Minnesota. I'm going to talk about some cases from outside of the state that either made national news or had some interesting quirks to them. The first of those is South Bay United Pentecostal Church versus Gavin Newsom. This was very similar to the Northland Baptist Church case that Anna discussed. Here, the plaintiffs sought a temporary restraining order to prohibit enforcement of Governor Newsom's stay-at-home order, which prevented religious services from operating at more than 25% capacity or with more than 100 attendees, whichever was lower. This went all the way to the United States Supreme Court on the request for a TRO or an injunction, and the court denied the request in a 5-4 decision. The majority, comprised of Chief Justice Roberts, Justices Kagan, Ginsburg, Breyer, and Sotomayor, held that the executive order was basically content neutral. It applied equally to all businesses, and there wasn't much of a difference between the attendance restrictions as applied to churches and secular businesses. And so it met a basic rational basis test for the restriction. The dissent disagreed, saying that it did apply unequally to businesses and churches or religious organizations, and held that while there was a compelling government interest, because it applied unequally to those businesses and religious organizations, it was not narrowly tailored to serve compelling government interests. So the dissent would have granted the TRO. But very similar to that Northland Baptist Church case. So we'll see how, if this has any effect on that case. Our next case from out of state also comes from California. And if we go to the next slide, this is a Tesla case you may have seen in the news. Here, basically, Tesla has a manufacturing facility in Alameda County that, under the executive order, seems to me that it would have been exempted from the stay-at-home order. The Governor Newsom's order exempted essential businesses, including auto manufacturing and electric motor manufacturing. Alameda County, however, issued an order prohibiting the manufacturing plant from continuing to operate. And this ultimately came to a head after Tesla continued to operate. Tesla filed a lawsuit saying that the Alameda County's order violated the preemption provisions of the state law, which Tim discussed earlier, constituted a deprivation of liberty and property in violation of the 14th Amendment and violated equal protection. And the argument on the equal protection point is interesting because they argued that their facilities in the county right next to Alameda County was allowed to continue operations while Alameda County was still closed. So ultimately, similar to the Shady's case, actually, Elon Musk said, we're just going to open our facility and continue operations, which they did. And then a week later, the county agreed in negotiations to allow them to continue operating. So we won't see how the court addresses that, but maybe an interesting strategy for businesses facing these kind of crisis, these orders. So next case we have is Bailey's Campground versus Mills. This is out of the District of Maine. Here, the executive order is kind of interesting in that it prohibits non-essential businesses from operating, but it also imposed a quarantine requirement on anybody entering the state of Maine. So if you were from outside of Maine and you entered the state, you had to quarantine for 14 days. But it also closed all hotels, lodging facilities, campgrounds, things like that. And so it seems to have effectively restricted travel into Maine to those who owned property or could stay with family within the state, which is kind of interesting. And so this complaint was brought by a group of campgrounds that wanted to cater to out-of-state people and also individuals from out of state who wanted to stay at those campgrounds. Now, the court addressed their two arguments on the motion for preliminary injunction, the right to travel and a procedural due process argument. The court seemed to actually pretty convinced that they had a relatively strong right to travel argument. I mean, the quarantine requirement clearly restricted out of state travel into the state of Maine. But the problem here was that the plaintiffs had failed to show that there was a more narrow restriction that could have been in place to prevent the compelling government interest of, that there was a more narrow restriction that could have prevented the dangerous outcomes that the government was trying to prevent. And so without a more narrow option for the government to impose, there was no point to issue the injunction. In terms of the procedural due process argument, this argument failed because, as the court noted, this is an emergency situation and there just hadn't been enough time to determine whether or not the plaintiffs had been denied functional or meaningful post-deprivation review. So they lost on that one as well. Our next case also involves some KOAs or campgrounds. This is Antietam Battlefield KOA versus Hogan. This is out of the District of Maryland. This kind of takes a more scattershot or hodgepodge approach to presenting claims. The plaintiffs grouped together businesses, individuals, political organizations, religious groups, kind of everybody they could find, and brought, seems to me, as many claims as they could. And unfortunately for the plaintiffs, they, on their motion for injunction, lost all of their claims, and the court denied the injunction. With respect to the business claims, they made two main arguments. One was that the restriction on gatherings, which we've seen in other cases, limiting gatherings to 10 or less people, was a violation of the Assembly Clause of the First Amendment. And the court said that this is a content neutral time, place, manner restriction. So you don't have any basis for getting an injunction at this point. With respect to the Commerce Clause, the plaintiffs argued that by forcing closure of in-state businesses, that would affect out-state suppliers who wanted to do business with them. But again, the court found that this wasn't discriminatory in any way because it was tailored to responding to the coronavirus crisis and not discriminatory against out-of-state parties. Our next case is Rock House Fitness versus Acton. This is an Ohio state court case that actually succeeded. And instead of challenging the executive order on the basis of a constitutional claim, this case challenged the order, which was issued by a state department, the Department of Health, on procedural grounds. basically the argument was that the state statute didn't provide the authority for the Department of Health to issue the order. And the court, under a fairly narrow reading of the statute, agreed, holding that it only allowed the Department of Health to quarantine or issue orders about quarantine to specific individuals as opposed to the state at large. Finally, the last case that I'm going to talk about is Wisconsin Legislature versus Palm. And you probably saw this in the news as well, made a pretty big splash. Here again, the claim succeeded, and it was again on a procedural grounds as opposed to a constitutional grounds. The Wisconsin Legislature brought this claim against the Wisconsin Department of Health, challenging the procedural process by which the agency had issued stay-at-home orders. And their argument was basically that the agency had not followed rulemaking procedures and that therefore the order was void. The court, over a strenuous dissent, held that that was correct, that this was a rule that was issued by the Wisconsin Department of Health and that it was void because it had failed to follow rulemaking procedures. So I think I'll turn it over to Steve to talk about the kind of takeaways that we have from the cases.
Things that jump out from the cases and the sort of general constraints that Tim described. One is businesses have an uphill battle when they're trying to challenge an executive order. The standard that often applies is whether or not government's acting irrationally or discriminatorily, and that can be a very deferential standard. So I think courts, understandably, given the long history of deference to government in the face of emergencies, are likely to be deferential. The second is the shorter the measure is in place, probably the better. Taking arguments get better the longer things go on. There are some other claims that are likely to have more traction if it looks like they are a permanent measure designed to deal with a long-term health problem. And, you know, because of the way that this virus appears to be proceeding, the temporary nature of a lot of these things, which courts have given a pass on, may seem more and more permanent. I think as the ebb and flow, as the virus ebbs and flows, we're going to see both the governmental responses ebb and flow, and some of these arguments that really aren't getting any traction because it appears to be a short-term or very limited measure, maybe begin to get more traction. I think too, the other thing that really jumps out here is when businesses have generally had success trying to challenge executive action in this area, they've more often won, not because there was a constitutional constraint, not because there was some sort of overreaching in terms of constitutional authority by the executive, either state or federal, but because the executive didn't follow the authorizing legislation appropriately. So Wisconsin probably being the best example of that court's view, which was that the executive had acted contrary to the authorization, which required legislative input. So I think those are the key takeaways. Thank you for being with us today. We're approaching our 60-minute time period. And if you have any questions, please, by all means, shoot us an email. We'll be sure to respond. Or again, you can contact anybody at Dorsey that you work with. Thanks for coming.